Diane Osei was 40 years old when her husband filed for divorce on a Monday morning in October. And she was still 40 years old 6 hours and 22 minutes later when she signed a $500 million acquisition agreement in a conference room on the 37th floor of a building in downtown Cincinnati, Ohio, and became the lead counsel of record on the largest transaction her firm had closed in. 41 years of practice. She had driven herself to the courthouse that morning in the 2014 Accord she had owned since before she made partner, because she was a woman who did not perform her circumstances for other people's benefit. She was served in the lobby by a process server who had been waiting since 8 o'clock. She accepted the envelope with both hands, the way you accepted anything significant, and she thanked the server, which was a habit she had from her father, who had believed that courtesy cost nothing and communicated everything. She placed the envelope in her work bag. She drove to the office. Her husband Leonard had filed through an attorney named Clark from a firm in Blue Ash, citing irreconcilable differences and requesting a division of the marital estate, which Clark had described in the petition as modest. The petition listed her salary at her firm, which was substantial but visible. It did not list the completion bonus she was hours from earning, which was not yet earned and which she had not discussed with Leonard because she had not discussed the deal with Leonard because Leonard had made it clear over several years and in several ways that her work was the part of her life he found most difficult to be married to. What Clark did not know. What Leonard did not know. What no one on Leonard's side of that filing knew, because they had looked at what was visible and concluded they understood what was there, was that Diane Osei had spent 14 months structuring a $500 million acquisition between two privately held pharmaceutical companies, a transaction she had originated through a client relationship she had built over 6 years. A transaction that had come within 3 hours of falling apart twice, and that she had held together both times through the kind of concentrated, patient, technically precise work that her name was now known for in 3 states. The completion fee attached to her lead counsel role was $3 million, paid upon execution, which would occur at 2 o'clock that afternoon. Leonard filed at 8:47 in the morning. He did not know what was happening at 2 o'clock. She had not told him. She had not told anyone outside the deal team and her attorney. She had learned a long time ago, from a woman worth listening to, that the work protected itself best when it moved quietly. What happened on the day Leonard Osei filed for divorce from his wife was not what he had planned, but it was exactly, in every detail, what she had built. Before we jump into the story, comment where in the world you are watching from and subscribe, because tomorrow's story is one you need to hear. The morning had begun the way most consequential mornings in Diane's life had begun, which was before 5 o'clock, with coffee she made herself in the kitchen of the house in Hyde Park that she had purchased 3 years into her marriage, with her own earnings, her own credit, and her own name on the title. Because she was a mergers and acquisitions attorney, and she understood that the correct way to hold any significant asset was clearly and in writing. The kitchen had a long window that faced east, which she had asked the contractor to enlarge when they renovated 2 years prior. Because she worked early, and she wanted the light to come in the way it did on mornings like this one. Low and clean across the countertop she had chosen herself, a white quartzite with a gray vein that ran diagonally from one end to the other, which she found aesthetically satisfying in the way that anything with a visible structure she could follow was aesthetically satisfying. She had her coffee and reviewed her notes for the 2 o'clock signing. The transaction had 14 exhibits, 3 side letters, a representation and warranty insurance policy that had required 4 weeks of separate negotiation, and a closing checklist that ran to 31 items, 28 of which were already complete. The remaining 3 were administrative, scheduled for the morning, and would be done before noon. She went through each one in the order she had assigned them. noting the responsible party, the expected completion time, the fallback if something moved late. Nothing was going to move late. She had closed enough transactions to know the shape of a deal that was ready, and this one had been ready for 11 days. She had been in this business for 17 years. She had closed transactions worth more in aggregate than she could state without a spreadsheet. She had never closed one worth this much in a single instrument, and she felt that in the way she felt most things that mattered, which was quietly and without performance, in the part of herself that kept an accurate record of what she had done and what it had required. Her grandmother, a woman named Adaize, who had immigrated from Nigeria with her husband in the late 1960s and had worked as a seamstress in Cincinnati for 30 years before opening a tailoring shop she ran until she was 78, used to say that the hand that does the work does not need to announce it. She said this in the particular way of women who had survived conditions that required them to be productive under observation and silent about the product, and Diane had understood it, even as a child, as more than a saying. It was an operating principle. You built the thing. The thing announced itself. Her grandmother had died 5 years before this morning. Diane still kept a photograph of her on the desk in the third bedroom she used as her home office. Beside the window that faced the garden she had planted her first spring in the house, which was now established enough that it produced without much asking the deep green reliability of something that had been given enough time and correct soil. She and Leonard had met in Cincinnati at a gallery opening 9 years before. He was an architect, warm-spirited and creative, and he had looked at the work on the walls the way she liked to see people look at things, which was specifically and with curiosity, and without performing either. They had talked for 2 hours and left together, and stayed in each other's lives with an ease that she had experienced only a few times before in her adult life and valued accordingly. The marriage had been good and then had become complicated, and then had become, in the last 2 years, something she recognized with professional clarity as a structure that had exceeded its load-bearing capacity. Leonard had grown resentful of her hours, and then of her income, and then of her professional standing in a way that he could not directly name, but that expressed itself in the small, consistent erosion of her presence in the space they shared. He made comments about her availability that arrived as concern and landed as criticism. He declined invitations to events that involved her colleagues. He said, more than once, that he felt like a secondary figure in her life. And she had heard that, and tried to address it, and eventually understood that the issue was not her availability, but the fact of her ambition itself, which was not an issue she could address without ceasing to be who she was. She had thought of her grandmother Adaize when she finally understood that. She had thought of the tailoring shop and the blue dress and the 40 years of work done quietly, under conditions that had not always made it easy. She had thought, the hand that does the work does not need to apologize for working. She had spoken to Felicity in September, a full month before the filing, not because she had been certain it was coming, but because she was a woman who looked at developing situations and took action before she needed to, rather than when she needed to. She had told Felicity that she believed Leonard was moving toward a filing. She had told her to prepare. She had answered Felicity's question about material assets with precision. There were assets that did not yet exist in a form that was disclosable, and they would exist in approximately 6 weeks. Felicity had looked at her over the reading glasses and said, "You're going to close it first." Diane had said, "I'm going to close it when it's ready to close, which will be in approximately 6 weeks." Felicity had said, "Understood," and had begun preparing. Leonard had left the house 20 minutes before the process server arrived. He had kissed Diane on the cheek in the hallway the way he kissed her on the cheek most mornings, which had once carried warmth and had become, in the way of things that changed slowly and without announcement, a performance of continuity that neither of them was genuinely maintaining. She had noted the new watch he was wearing, a purchase she did not recognize from any occasion or conversation she could place. She had noted that he took his gym bag, which he did not ordinarily take on Monday mornings. She had noted these things in the way she noted discrepancies in a deal document, without reacting, simply registering, and she had gone back to her checklist because there were 3 items to complete before noon, and the morning was not going to extend itself on her behalf. Only Felicity and the deal team knew the full picture. The process server was waiting in the lobby at 9 minutes past 8. She accepted the envelope. She placed it in her bag beside the closing checklist and the red-tabbed execution copy of the acquisition agreement. She thanked the server. She drove to the office. The elevator doors opened on the 31st floor at 8:43, and Diane walked through the glass doors of Mensa Ose LP, which she had co-founded with Felicity 4 years prior after they had each determined, separately and then together, that the firms they worked for were not structured to give women like them the authority their work had already earned. The firm had 12 attorneys, 3 of whom were women of color, which was a statistic the firm had never made the subject of a press release because Felicity believed that the work should carry its own case. The firm had been profitable in its 2nd year. It had originated this transaction independently, through the client relationship Diane had maintained through 2 prior firms and brought with her when she left, because it was hers. It had always been hers, built through 17 years of technical excellence and the particular patient consistency of someone who understood that client relationships were built in the intervals between crises, not during them. Felicity was at her desk with her reading glasses on and a legal pad already open when Diane arrived. She looked up. She looked at the work bag and the way Diane was carrying it, which told her what she needed to know before anything was said. Diane set the bag on the guest chair. She removed the manila envelope and placed it on the desk. Felicity read the petition in full. She set it down with the particular evenness of a woman who had anticipated its contents and was not confirming information so much as beginning to work with it. She said Clark's name once, flatly, and then she said, "He doesn't know about the 2 o'clock." Diane said, "No." Felicity said, "What time is the execution?" Diane said, 2 o'clock. Felicity looked at her with the expression she wore when she was calculating something she found satisfying in the way that clean outcomes were satisfying. She said, "I'll have our response ready to file by 4. She said, "Let's go close your deal." The signing happened in the conference room on the 37th floor of a building leased by the acquiring company, a room with floor-to-ceiling windows that looked out over the city in all directions, and a table that seated 24 and had been set for 14, which was the number of people required to witness a transaction of this kind. 2 lead attorneys, 2 companies' executive teams, the Representation and Warranty Insurers Council, 4 paralegals with the execution copies, a notary, a court reporter retained at Diane's insistence, because she was a woman who believed in complete records, the acquiring company's general counsel, a man named James, who had worked with Diane on one prior transaction and who had specifically requested her for this one, had asked her that morning how she was. She had said she was well, which was true in the sense that mattered, which was that she was present and prepared and ready to close. He had looked at her once with the particular attention of someone who suspected there was more behind the answer than the answer contained, and then he had nodded and moved to his seat. The transaction had come within 3 hours of falling apart twice. The first time was 14 months ago, when the selling company's board had lost confidence in the valuation methodology and demanded a revised independent analysis. Diane had produced it in 72 hours without sleeping more than 4 of them in any given night, working from the data room on a laptop in her home office while Leonard slept and woke and moved through the house as though her presence in it was incidental. She had not told him what she was working on. She had told him she had a filing deadline. He had said okay and gone to bed. The second time the deal nearly fell apart was 6 weeks before the closing, when a material misrepresentation was found in the environmental compliance schedule during a final due diligence review. The acquiring company's board had convened an emergency session, and their general counsel had told Diane in a call at 7 in the morning that they were considering invoking the material adverse change clause and walking away from the table. She had asked for 48 hours. She had spent 11 days rebuilding the environmental representation from the underlying regulatory filings, working with 2 specialists she had called in on a day's notice, holding the acquiring company's board on the telephone 3 times across those 11 days, managing the timeline while managing the substance, while managing the relationship, all simultaneously, with the disciplined focus of a woman who had been doing this long enough to know that the difference between a deal that closed and a deal that collapsed was usually one attorney who refused to let it fall. She had not told Leonard about either crisis. She had come home on the nights of those weeks and cooked dinner and asked about his projects and listened to the answers, and she had gone to bed later than she intended and gotten up before 5 and continued. The work was the work. It did not require his understanding to proceed. The execution copies were distributed at 1:54. Diane reviewed her copy page by page with the attention she had given to every draft of the document over the preceding 14 months. She knew every clause. She knew every negotiated departure from the initial term sheet. She knew which representations had been hardened and which had been qualified, and why each decision had been made, because she had made them. It was her transaction. It was finished. She signed at 2:14. The court reporter noted the time. She set the pen down. The room was quiet for a long moment, in the particular way that rooms went quiet when something significant had finished happening, and the people in it were adjusting to the fact of its completion. 14 people at a table that seated 24. And not one of them said anything for 4 or 5 seconds, because some finishes deserved a beat of silence before the business of what came next began. James extended his hand across the table. He said it was a privilege to work with her. He said that in the way of a man who did not use the word privilege loosely. She shook his hand. She said the privilege had been mutual, and she meant it. He had been a rigorous, fair counterpart through 14 months of a transaction that had tested both of them, and that counted for something she recognized and did not often state aloud. She gathered the execution copy that was hers, the original, signed, notarized, court reporter's certified copy of a $500 million agreement that bore her name as lead counsel. She placed it in her work bag beside the divorce petition she had received that morning. She drove back to the office. Felicity had the response ready at 3:45. It was filed at 4:02. Clark received electronic service at 4:07. Felicity's response included a notice that the marital estate was broader than the petition had accounted for, and that there were assets not reflected in the petition's financial summary, and that full disclosure would be provided through the standard discovery process. Clark called Felicity's office at 4:30. The call lasted 9 minutes. Felicity called Diane afterward and said only that Clark had asked for an extension of the initial response deadline. She said she had granted 3 days. She said, "Give me until Thursday to show him what he's working with." Diane said, "Take the full 3 days." The completion fee cleared into the firm's trust account on Wednesday morning. Diane's share, as originating and lead counsel, was documented in the partnership agreement that she and Felicity had drafted and executed and had notarized and filed with the state bar, all of which had been done in the ordinary course of running a law firm, and all of which was therefore available to any party engaged in discovery. Clark called Felicity on Thursday at 10 in the morning. He was on the call for 14 minutes. He called again at 2, which was a shorter call and a different conversation. The settlement negotiation that followed took 3 weeks. It was not contentious in the end, because there was nothing to contest. The marital estate was what it was, and Felicity had documented every element of it with the thoroughness of a woman who had been preparing for this specific negotiation for 47 days. Diane's individual professional assets, her equity in the firm, her client relationships documented through retainer agreements in her name, the completion fee earned on the date of closing, were set out in a summary that Felicity had formatted with the same care she brought to any complex instrument, clearly in chronological order, with every supporting document indexed and attached. Clark had done the best he could with what he had. His client had filed on a woman he understood to be a salaried attorney at a law firm. The salaried attorney was also a founding partner of the law firm, with an equity stake that had been valued by an independent business appraiser the previous year, and that was documented in the partnership agreement on file with the Ohio State Bar. The completion fee had been earned during the marriage and was subject to equitable distribution, which Diane had never disputed. Her attorney computed the equitable share. Her accounting team had already prepared the full analysis. It was the number it was. Leonard received his equitable portion. He received nothing more. The settlement was signed 3 weeks to the day after Diane had signed the acquisition agreement. She had not seen Leonard during the negotiation and had not spoken to him. Her communication moved through Felicity, which was the correct channel for that period, and she had found that she did not miss the alternative. She had thought, more than once in those 3 weeks, of the morning she accepted the envelope, the way she had placed it in her bag beside the closing checklist, the way the 2 documents had ridden together to the office, the end of one thing and the completion of another in the same bag, separated by the thickness of a legal pad. She found that image fitting in the way that things were fitting when you had spent enough time on them to see the full design. 7 months later, Diane Osai sat in her office on the 31st floor on a Tuesday morning, the window behind her facing east over the city, her coffee at the corner of the desk beside the photograph of her grandmother Adaize in the tailoring shop on the day she opened it, 1991, standing behind the counter in a blue dress she had made herself, looking at the camera with the expression of a woman who had built something and knew it. The firm had brought on 2 new associates since the acquisition closed. Diane was 3 months into the origination of a second transaction for the same acquiring company, smaller in scale but more technically complex, and she had told James at their first meeting that she expected it to take 12 months and that she intended to close it in 9. He had looked at her and said he believed her entirely. A man named Kwame, who was a cardiologist she had met through her cousin, and who had asked her to dinner twice before she had availability that was genuine rather than polite, was coming to dinner at her house on Saturday.
He had asked the right kind of questions across 2 dinners, or 2 dinners, which was the kind of information she collected. She had not decided what she intended about it, and was content not to decide for a while longer, because she was a woman who moved deliberately on the matter, and this one was beginning to matter, and this one was beginning to matter. Leonard had left Cincinnati 4 months after the settlement was signed, taking a position with a firm in another city. She heard about it from a mutual acquaintance who mentioned it the way people mention things they expected to require no comment. She had said that she hoped he was well. And meant it in the flat and honest way that had nothing to do with him and everything to do with who she chose to be. On the Tuesday morning 7 months after the closing, Diane finished her coffee, set the mug at the corner of her desk the way she set it every morning, and opened the origination file for the new transaction. She looked at the structure she had begun sketching the week before across 3 pages of a legal pad, It was not complete. It was a beginning which was the only state a structure existed in before the work of building it started. And the work of building it had always been the part she found most true about herself. Her grandmother had said the hand that does the work does not need to announce it. The hand had done its work. The work had announced itself on a Monday in October at 2 o'clock and 14 seconds. She had built everything worth keeping. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.